statements are being made. I don't, you know what? You want to keep shaking your head? I'll wait because I got all day. Are you done shaking your head? You don't have to agree with a darn thing I'm saying. But I'll be darned if you're going to sit here and disrespect me in my courtroom like you did them in the hallway. That's not going to happen, ever.
It's your boy Oouchie, Oouchie Court Watch, where we say what everybody in that courtroom's thinking but won't say out loud. Today we're doing the whole hearing. A woman out on bond who decided the move was to sit in the courthouse hallway and go at the witnesses against her on camera. And Judge Simpson is about to walk her through exactly how that math works out. Let's get into it.
Ever. It does call the case of the people versus Debian.
Good afternoon again, Your Honor. The people.
Good afternoon, Your Honor. Justin Zane appearing on behalf of Davion Morgan City.
Yep, I'm Morgan.
Okay. All right. Where are we on this?
Your Honor, I've had an opportunity to show defense counsel the video as well as audio that I referenced previously to the court's my understanding that we are having a hearing on this bond violation. I do have the witness present and ready to begin whenever the court wants.
That's correct. We're ready to proceed.
All right. Go ahead.
All right. So now the actual hearing starts. Bond violation hearing. People versus Davion Morgan. She's out on bond. And the state says she spent her hallway time going at the witnesses against her. And you already saw the judge's mood in that cold open. He is not in a playing mood today.
All right, I'm ready.
Call Stephanie Sinks.
And please come forward and be sworn.
Please spell your first and last name for the record.
Sure. First name is Stephanie, Stefanie. Last is Sinks, S as in Sam, INKS, Sam.
All right, thank you. May inquire.
Good afternoon, Stephanie. How are you doing? Stephanie, how are you involved with this case?
I am the guardian for Ms. Joyce Glover.
And that's the named individual on the complaint, is that correct? Where were you this morning at about 10:50 a.m.?
Stay outside of the courtroom.
Where outside the courtroom?
Go out these doors. I was on the bench.
First witness up is the guardian. And here's the detail that matters. She's the legal guardian for the elderly woman at the center of this whole case. So she's not some random bystander. She's standing in the hallway on a bench when all of this goes down. Keep that in your pocket.
Verbal comments in my direction.
What sort of verbal comments?
Started off, I believe it was a skinny ass cracker, and then went on to a number of other things, making comments about a bitch and a hoe, and that I wasn't going to get away with this. The gist of it was that she was going to keep stalling it, taking it to trial, taking it to trial, and taking it to trial. It just kept going for about probably close to 2 minutes.
And here's the testimony. For about 2 minutes, Morgan's firing off crackheads, slurs, the whole ugly mouthful. And then the line that's actually evidence. You're not going to get away with this. Take it to trial. Take it to trial. That's not a bad mood. That's a message delivered a few feet away in a building full of cameras.
Did you record any of that interaction? And did you have an opportunity to listen to that recording prior to taking the stand? Would you recognize it if you heard it again? Or if I can plug in and just play a second just for foundational purposes.
And just so I'm clear, you were recording this?
I started to record it after probably about 30 seconds of
Okay.
I realized I wasn't actually looking in the direction of Ms. Morgan or Devion, but I could see her turning back and looking at us, so I started to record it at that time.
Gotcha.
And what were you recording on, ma'am?
On my cell phone.
And I'm going to play again just the first second here of while Morgan _ recording just for foundational purposes. So I just played about the first 4 seconds. Ma'am, do you recognize that audio?
If you could play a little bit more.
I'll turn it up a little because it's a little bit quiet. You recognize that audio? Is that the audio that you recorded today?
And the state isn't just leaning on her memory. The witness recorded it on her phone. So they played the audio right there in open court. Rule 1 of running your mouth in a courthouse. Assume every word is being recorded because it was.
The courtroom.
And how do you recognize this video? Do you see yourself in it anywhere?
To the right, the far right, in the white jacket.
I don't know. My mouse does come up. Is this you right here?
That is, yes, correct.
All right. And have you watched this video before? And is this a fair and accurate reflection of what happened in the hallway? Your Honor, I move to admit what's marked as People Proposed Exhibit 2 for the purpose of bond violation hearings.
Any objection of what here?
There we go.
Permission to publish?
Yes.
And just for the record, this is about a 5-minute, 9-second long video. There is no audio on this one. I am pausing at the 30-second mark. Ma'am, do you see the defendant anywhere in the video at this point?
Yes, she's sitting on the bench to the left of the door.
And now this, they roll the hallway surveillance. 5 minutes of it, no audio, the whole courtroom just watching the screen. And the witness points herself out, then points out the defendant sitting right there on the bench. This is where the case turns. It's not he said, she said anymore. The judge is watching the tape with his own eyes.
I'm gonna pause it at 4 minutes, 30 seconds. The last 30-ish seconds, that informant, certainly if the court wants to play it, I can't.
Pardon?
I'm gonna just pause it here.
That's fine. Whatever.
Can we take me off, please? Prior to the defendant making any comments to you, had you said anything?
They run the tape all the way to the 4.5 minute mark. And then the question that cuts through everything. How did it make you feel? And she says it plain, intimidated, like somebody was trying to scare her off. That one word is the whole hearing.
To the defendant? Did you ever say anything to the defendant today? How did it make you feel when the defendant was saying these things to you?
Intimidated. I think that she was trying to intimidate me.
And just to clarify, ma'am, what is your understanding of why you were subpoenaed to testify or subpoenaed to be here today?
Because of identity theft, and I'm not sure of the exact charges, but what I believe were financial exploitation issues for a elderly, vulnerable adult.
And were you prepared to be a witness in that case? And were you prepared to testify today? If I can have one moment, please, Your Honor.
Nothing else at this time. Thank you.
Cross-examination.
Just a few questions, ma'am. We just watched that interaction on, I believe, exhibit B or 2. Appeared to be roughly 5 minutes. Anytime during that interaction, did Miss Morgan say your name or otherwise address you personally?
Also known as a cranky, skanky ass cracker.
And here's what makes it land. What's the case she's a witness in? An allegation of financial exploitation of an elderly, vulnerable adult. So allegedly, you take advantage of a vulnerable senior, and when the witness shows up to testify, your move is to corner her in the hallway. The judge is doing that exact math right now.
I'd ask the court to strike that from the record. I asked if she'd mentioned.
I think she answered your question.
At any point in time, did you observe Miss Morgan leave the bench that she was on and come towards your bench? And at any point in time, did you see Miss Morgan gesture either with her hands or otherwise towards you in any way? Okay, and what exactly did she do in order to gesture towards you?
So you can see on the video, I did not turn to look at Miss. Can you clarify, Miss Morgan? Is that
Yeah.
Okay, Miss Morgan? I did not turn and look at Miss Morgan this way, but periodically I looked toward the window, and I could see her gesturing toward, turning around and gesturing and moving.
Okay.
Right.
So towards this direction, but could you confirm whether it was towards you or down the hallway?
It was toward Diane and me.
Okay. Were you aware where her counsel was, myself, where I was positioned at this time during that 5-minute interaction?
At the courtroom.
Okay. And at any point in time, did you see me head down that hallway?
I believe at one point, yes.
Okay. And so when you saw Miss Morgan gesture towards that way, how were you able to discern that she was pointing at you versus talking about her counsel?
So I'll see you down the hallway.
Okay. And it's my understanding.
Now the defense gets its shot, and the attorney's working a real angle on cross. Did Morgan ever say your name? Did she leave her bench and walk over? Did she tell you not to testify? He's trying to build that it was vague venting, not a targeted threat. It's a fair cross, but watch how the witness holds up.
Okay, that's all I have.
Any redirect?
No, Your Honor, I'd ask.
Just one question. Was that Miss Plummer that was seated next to you?
No, the woman sitting next to me was Diane, who's next to Detective Quinn.
Gotcha.
She's one of the witnesses that was testified today.
Okay. All right.
Nothing further, Your Honor.
All right. You may step down. Thank you, ma'am. Any additional witnesses?
No, Your Honor.
All right. Any witnesses for the defense?
Okay.
All right. Thank you. Argument.
Your Honor, I would ask that the court find the defendant violated the conditions of her bond, namely the no contact, or I believe she was ordered not to have contact with Stephanie Sink. I believe she was also ordered not to have any new criminal conduct. I'm not sure if it was ordered. I believe had a written on the pretrial release order, but typically there's a condition not to have any assault, intimidating, threatening, or harassing behavior. If that is an order, I believe it would be a violation of that order as well. The court saw the video and heard the recording that the defendant was making some pretty serious derogatory remarks about witnesses in this case, calling them bitches and hoes. The court saw the video, could see that the defendant was.
And she doesn't crack. She keeps it simple. Morgan was turning and facing her, and the comments were about coming after her, taking it to trial, getting an attorney. Is she 100% certain? She gives an honest answer, but the direction, the posture, and the timing all point one way.
Intimidating these witnesses. At any point in time, she could have stood up and said something to them, turned around and pointed at them, used their names as she knew who the witnesses were. There was no intentional direction towards these two witnesses to try to intimidate them not to speak when we already knew that they were here to speak. And so if that was going to happen, Your Honor, it would have happened the last time that they were here in order to testify at the preliminary exam. She's shown up at every single hearing. These witnesses have been there before that 5-minute window. After that 5-minute window, there was clearly nothing that would show or otherwise indicate that she's trying to intimidate them. They were here at the last hearing. Obviously, she knew that they would be here again. And at that point in time, without, getting into it, but kind of getting into it, is that we had already decided that we're waiving the exam and moving forward. So any effort to intimidate and otherwise encourage the witness not to testify would have been moot, because we were waiving the exam and moving forward with the case up in circuit court. What we decided to do at that point in time remains to be seen. But for today's purposes, there was no effort to intimidate those witnesses because we had already made the decision to move forward, and there was not going to be an exam today.
So intimidation.
So the defense lands the plane. My client was venting general frustration to the women next to her. She never stood up, never pointed, never used their names. So there's no intent to intimidate. Honestly, that's the best version of that argument you could make. The problem is the judge already watched the tape.
From the video, from the recording, from the testimony you heard.
Counsel, you going to tell me that when I look at that video and that aerial view, that your client is facing in the direction of her sinks, and the words that are being spewed from her mouth aren't directed at her?
Well, I wasn't there myself, Your Honor. I can go off.
Counsel, don't play word games with me. You heard the recording.
Yes.
You see the posture of your client as she's sitting on the bench. And are you arguing before me that that was not intended at the two witnesses, inclusive of Ms. Sings, as they're sitting there?
No, I'm not trying to insult the intelligence of the court. You saw what I saw.
Thank you.
Speak for itself. And so I'm not going to sit up here and say that. What I would indicate is that I think that my client's expressing a general frustration about her case, as opposed to utilizing those words to try to intimidate them not to testify. That's what I would indicate to the court. What is it? I just want to explain.
And here's where Simpson shuts the door. He goes, "You're telling me that on that aerial view, your client is facing the direction of these witnesses, and the words coming out her mouth aren't aimed at them?" And then, counsel, don't play word games with me. That's a judge who did the geometry and is done pretending it's close.
Briefly, Your Honor, if it were just the language and the derogatory terms, I think maybe that argument might hold weight, but I think that consider that the defendant also stated after this is over, I'm going to get lawyers and come after you or something to that effect. I don't remember the exact language. I think that clearly shows.
Yeah, hold on a second. Time, you've interrupted Mr. No, do not do it again. Otherwise, I don't have to deal with it. Oh. Go ahead, Mr. Cook.
Thank you, Your Honor. I believe that language clearly shows that intent, that this is directed at these witnesses, and it clearly, as the court heard, had the effect of making these witnesses feel afraid. I would again ask the court revoke bond.
With respect to that statement, my finding.
Then the state drops the one that ends it. Forget the slurs. She also said, after this is over, I'm getting lawyers and coming after you. That's the line between mad and menacing. You can be frustrated all day. The second you tell a witness I'm coming after you, you've crossed into intimidation, intent established.
So it's just sort of god-awful statement with an attempt, clearly in this court's mind, to intimidate Ms. Sinks and the other witness and to testify, so that we're real clear in terms of her bond conditions. She is not to have any direct or indirect contact with the following persons, and that includes Stephanie Sinks. That is condition S on the bond form. That is just clear. She's about to have contact. That is a very big, long hallway. The courtroom is a reasonably good size. The defendant could have come and sat in the courtroom at any given point in time. She knew who Miss Sinks was. She knew exactly who she was talking to in the hallway. She could have come, Miss Sinks wouldn't move. She could have come and sat in here. And that's her obligation, is to avoid contact with Miss Sinks, either directly or indirectly. She purposely did that. I think she did it. You know, when people come to court, whether it be a defendant, whether it be a victim in a case, whether it be a witness, they are not to be intimidated into doing whatever they're doing.
And here's the legal heart of it. She had a no contact order, condition S, in writing. No direct or indirect contact with this witness. And the judge spells out the obvious. It's a huge hallway. There's a whole courtroom she could have waited in. She knew exactly who that witness was. She did not have to be anywhere near her. She chose that bench. That's the ball game.
The court, after listening and seeing all of that, having heard argument, is going to find that the defendant was involved in the yelling and inappropriate phrasing at protected parties to the case in the 14A1 hallway, and that the court does believe was an attempt to intimidate the witnesses. Not tolerated today. It will never be tolerated in this courthouse. And so that we won't have a return of this at all, defendant's bond is hereby ordered revoked. Defendant is remanded to the Washtenaw County Jail.
Two really quick matters. I apologize. I neglected to mention earlier, I would also ask the no contact order include the other witnesses that were present today that were set to testify. I can provide that in the court now, or I can provide that in writing at a later date and time if the court would prefer.
If you could somehow or another get those other names on an order for the court to sign, I will add those individuals.
And then may I approach to sign the information I failed to do today?
Yes, you may.
And there it is. The judge finds it was a clear attempt to intimidate the witnesses, not tolerated today, never tolerated in this courthouse, and the bond is revoked. Straight from the gallery to the county jail. The free game, fam. A courthouse is the last place on earth to break a no contact order. Cameras everywhere, the witnesses right there, and the one man who decides if you go home is watching every second. Don't hand him the case against you. That's the whole hearing. She walked in on bond and walked out in handcuffs over a hallway she never had to sit in. If you want full court breakdowns with the law behind every single move, like and subscribe to Oouchie Court Watch and share this with somebody who thinks no contact has a hallway exception. It does not. Your boy Oouchie, out.